Let's talk about something that's really tough, but also really, really common for a lot of people facing serious financial difficulty. It can feel incredibly isolating, but you're not alone. So today, we're going to dive in and unpack the options available to Canadians who are navigating debt with a close look at how bankruptcy actually works. Just take a look at this number. Over 143,000. That's how many individuals and businesses in Canada filed for insolvency in 2024. And that's not just some abstract statistic. Those are people, families, and entrepreneurs. And it really shows you just how widespread this challenge is. And this isn't a problem that's standing still. As you can see from this chart, that big number from 2024 is actually a 12.1% jump from the year before. So more and more Canadians are hitting a point where they need a formal way to deal with overwhelming debt. So the big question is, what are those formal solutions? Okay, we've seen the scale of the problem. Now let's get into the solutions. To really get a grip on the options, we first need to define a few key terms and meet the one professional who is legally authorized to guide you through this whole thing. Everything kicks off with this state, insolvency. Now, this isn't a legal process, not yet anyway. It's simply the financial situation of not being able to pay your bills as they come due. Think of it as the starting point, the trigger that makes you look for a real legal remedy. And one of those remedies is bankruptcy. This is the one most people have heard of, right? It's a formal legal process all laid out by federal law, and its entire purpose is to give what the law calls an honest but unfortunate debtor a fresh start when they just can't repay what they owe. And here's the thing, you do not navigate this journey alone. In fact, you can't. The only professional in all of Canada who is legally allowed to handle these proceedings is a licensed insolvency trustee, or LIT for short. They're federally regulated, and you can think of them as the official referee of the process, making sure everything's done by the book for creditors, while also making sure your rights are protected. So once you meet with an LIT, you're generally looking at a choice between two main paths. The first is bankruptcy, which we're digging into, but there's a second option called a consumer proposal. It's absolutely critical to know that there isn't just one road. There are two main options on the table from the very beginning. All right, so let's say you've met with your LIT and decided bankruptcy is the right path for you. What happens the second you file that paperwork? Well, the impact is immediate and it is powerful. This legal speak on the screen, it's pulled right from the law, and it describes something called a stay of proceedings. And honestly, this is a huge deal. What it means, in plain English, is that the collection calls stop. The threatening letters stop. Any wage garnishments stop. It legally blocks most of your creditors from contacting you or taking action against you. It's like hitting a giant pause button, giving you that instant relief and breathing room. Now, all that breathing room is crucial, but it doesn't mean the process is completely free of obligations. We're about to get into one of the most important and, frankly, one of the most confusing parts of bankruptcy, figuring out what you actually have to pay. And it all boils down to this concept called surplus income. This is it. This is the fundamental question for anybody even thinking about this path. And the answer isn't a simple flat fee. It's a specific calculation based entirely on your personal situation, your income, and the size of your family. So the government actually sets the rules here. The law defines surplus income as any money you earn above a preset government standard for a reasonable cost of living. It's not about how much money you feel you have left over after your bills. It is a very specific legal calculation. And we really need to nail down this difference because it's critical. On the one hand, there's a budget surplus. That's what we all hope for, right? Your income is more than your expenses, and you've got money left to save. That's great. But on the other hand, there's surplus income in a bankruptcy. That's a totally different beast. It's a mandatory payment you are legally required to make to your creditors. They are not the same thing at all. So how is it calculated? Well, your LIT follows these 4 basic steps. First, they figure out your family's average monthly take-home pay. Second, they subtract the official government standard for a family of your size. Third, if what's left over is more than $200, then ding, 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 you officially have surplus income. And finally, step 4, you're required to pay half, 50%, of that surplus amount into your bankruptcy estate every single month. Let's look at a real-world example to make this super clear. On the left, you've got a single person making $3,000 a month. The government standard for one person is about $2,700, so they're over the line by $334. The required payment, half of that, which is $167 a month. But now look what happens on the right. Say their income drops during the bankruptcy. The LIT recalculates everything, and their new average income is now below the government standard. And what happens to their payment? It drops all the way to zero. The system is designed to be flexible if your life changes. Okay, so we've just gone through the mechanics of bankruptcy, especially that really key surplus income calculation. Now let's zoom back out. Given the choice between bankruptcy and a consumer proposal, which path are most Canadians actually taking? And this is where it gets really interesting, because the trend is crystal clear. In 2024, out of all the consumer insolvencies filed, a staggering 79% of people chose a consumer proposal. Only about 21%, just 1 in 5, actually filed for bankruptcy. Yeah, the numbers don't lie. Even though bankruptcy is the term everyone knows, the data shows that consumer proposals have clearly become the #1 tool for Canadians looking for a structured legal way out of overwhelming debt. And so this leaves us with a final, really important question to think about. Now that you understand a bit more about the bankruptcy process, especially the potential for those mandatory surplus income payments, what do you think is driving almost 4 out of every 5 Canadians to choose the alternative path instead?